everybody. Good afternoon. How is everybody today? This is supposed to start at 1 p.m. and we are allowed to stream this one. So if you haven't done so already, please smash that like button on your way in. Let everybody know that we are live. Hello, Kimmy, Dog Mom, Vera Ray, Warriors of Justice. Hello, hello, Marriott. Hello. Please smash that like button on your way in. Shadow of Lotus. Hello. Jubes. Hello. On your way back in after hitting the like button, please make sure you have live chat selected at the top of your chat. Hello, Vicky, Marie. Hello, hello, my dear. Shannon's Copper, Doc's wife. Hello, hello, everybody coming in. Please smash that like button on your way in. Let everybody know that we are live. Hello, Doc's wife. Hello, Nana Woolan. Jack, hello, hello. Hello, Terry. Please smash that like button on your way in. Let everybody know that we are live. This is going to be getting going very shortly. I have all the screens up and waiting so we can watch this live. Hello, Steffi. So yes, this is going to be live today. So you are going to be able to see inside the courtroom today. Hello, Mama. There's my mama has just popped in. There's my mom. Everybody say hi to my mama. My mama's in here. Nice to see you in here. So like I said, everybody, it's going to be starting in about 10 minutes. We are going to be able to stream it live from the courtroom. There you go, Mama. Everybody saying hi to the mama. It's not often she comes in here. So when I let you guys know I got to go next door, Mama needs me for something, that's Mama. Everybody knows who Mama is now. It's nice to have her living right beside me. So with that being said, did you guys get to see, there we go. There, Marie, there's one of my mods, Mama. She's saying hi, Mama. Yeah, we get to finally see inside the court. I do have some filings from Letitia, what happened with Letitia Stout. So far, I guess that has been moved. I thought that would be going ahead this morning, but no, it's been moved to April 14th. Chad is also back in court again tomorrow. I'll be starting that at 11:15 a.m. tomorrow morning. He's back in court again tomorrow. So if you guys haven't seen too, I did a short video this morning. It's up on my page under videos. The latest filings from the Barry Morphew case. It's not what we expected. There is some stuff there, but we're still waiting on the sanctions, if there's going to be any. And he hasn't ruled yet on the defense's motion to dismiss. Hello, Lorna, Dana, Fluffy Hedgehog. Hello, everybody coming in. Brenda, Warriors of Justice. Mariah T, hello, hello. So hello to everybody coming in. Smash that like button, please, on your way in. Let everybody know we're live. 39 likes and 68 viewers. Come on, you guys. It's free. Oh, Nana, I'm so sorry to hear that. 67 tomorrow. Well, happy birthday. A day early. I will be live tomorrow. So if you're in here tomorrow, I will give you a big birthday shout out. I'm so sorry to hear about that. Stay strong. Good afternoon, Nan. Welcome, welcome. See a lot of members in here also. Please smash that like button on your way in. Just click off on the live chat. Go out, smash that like button. When you do come back in, please make sure you have live chat selected at the top of your screen. Oh, the real angel. Hello, hello. So I am going to be clicking a lot. You'll hear that just so I make sure I have it ready to go when this starts. Hello, Nana, WWG1WGA. Yes, Nana is also battling cancer too. So to the both of you and anybody else that is battling, my thoughts and prayers are with you. Stay strong. Don't get yourself down, because keep positive and positive things happen. Warriors of Justice, sending healing prayers. Well, that's really good. Really, really good that they caught it early, Nana. You have a very good chance of becoming cancer-free. But we're still going to send you, I got goosebumps top to bottom here. We're going to still send you healing prayers. So as I was saying, I did do a video earlier this morning. It is up. So once this live is done, if you want to go over and check that out, it's the latest judge's orders. I'm still waiting on 2 more orders to come out regarding the Barry Morphew case. I am keeping an eye on that. So as it becomes available, I will be bringing it to you. So go on over and take a peek at that once this live here is done. So I'm wondering if Mr. Wonderful Chad Daybell, and I say that as pun, is going to be in the courtroom today. We don't know. And like I said, we will be live again tomorrow. He is back in court tomorrow. Unless today they can take care of everything today, which I don't think they will, because today is a lot of motions, and tomorrow is going to be a status conference and some more motions. So what they can't get done today will fall over into tomorrow, and I will be live for that too. That one starts tomorrow morning at 11:15 a.m. Eastern. 53 likes, 77 people in here. Please go smash that like button. Let everybody know that we're live. It helps with the algorithm. And this should be starting momentarily. We got about 6 minutes out. So if you haven't grabbed yourself a coffee, grab yourself a coffee and sit down, and let's get ready to hear what's going on here. Thank you, Dana. Thank you to everybody who went out and smashed that like button. It helps bring the algorithm up so we can get going here. Live coverage. You're going to be seeing the courtroom inside, what's going on as it happens. Nana says, Mr. Dumbbell. Oh, I love that. So as it's happening, we're going to be able to see what's going on. I'm anxious to see if Chad is going to be in the courtroom, or if he's going to be, he's probably going to be coming by video, but we'll be able to see and hear everything as it goes on. And it saves my voice, right? Also, like I said, Letitia Stout was supposed to be in court today, but that has been put off to April 14th. Hello, Joy. Welcome, welcome, everybody coming in. Please smash that like button on your way in. It gets us up there in the algorithm, lets everybody know that we are live. And smashing the like is free. I don't mind if you want to send a super chat or super sticker, but it's not required. Smashing the like button is absolutely free. So, hey, well, I'm going to be listening to this, but I'll be traveling back to Tennessee tomorrow, so hate to miss the live. Well, you can listen on your way, and safe travels, my friend. Yes, happy birthday to Nana Woolen tomorrow. Oh, there goes my tummy. Okay, as soon as this starts, you guys, I will make it full screen and we will go over there so you guys can watch and hear everything as it's happening. Okay, just give me a second, you guys. I'm gonna surprise my sister isn't here. Let me just give her a quick text. I don't know how busy she is, so hopefully she will be popping back in there. And Nan Pelosi says, happy birthday, Nana. We'll do hello, Crime Bee. Janika, hello. Muffin Top, hello. Bonnie Baker, hello, hello. Welcome, everybody. Please smash that like button on your way in. Very welcome, Grammy 3G. Happy birthday. There's Missy. Missy. I missed you, Missy. Smash it anyway. Jerry, hello. Babs, hello. Good morning, good afternoon, good evening, whatever time zone you're in. Yes, St. Patrick's Day. Happy St. Patrick's Day, everybody. Okay, why? Wait a minute here. Missy Richmond, why are you not showing up? There you are. Sorry, you guys, if you can hear that dog barking in the back. It's a pain in my butt. People like that shouldn't even have dogs. It barks nonstop. So sorry if that is, you can hear it over the mic. My mic is pretty sensitive. Okay, anytime, guys. You've got a few minutes. 69 people in here, 108 people in here, 70 likes. Please smash that like button. Exit live chat. When you come back into live chat after hitting that like button, please make sure you have live chat selected at the top of your screen. It's really nice here today, too. We're supposed to hit up to 16 degrees Celsius, so I hope we get that weather today. Yeah, I've got a dog that keeps me awake at night across the street. They let that poor thing bark nonstop and cry. It was out there in minus 35. We've called bylaw and everything, and they don't seem to be doing nothing. So Dob says, hi, everybody, and smashing the like. Thank you, thank you. It lets everybody know that we are live. So yes, please hit that like button. It's free to do. And also shows your appreciation for me doing this. And makes me want to do more of these for you and bring you live stuff. It's a lot to get these things up and going and running and on time and whatever. So it shows your appreciation. So thank you very much to everybody who's smashing that like button. Marie, don't say pain in the butt. You pulps that way. Yes, everybody saying Happy Patrick's Day. Yeah, we do. All the neighbors keep calling, and it just seems bylaw is just dragging their feet. But we're on it, believe me. Rain in Connecticut. Yeah, like people like that don't deserve. I mean, the bylaw infractions they got. Looks like a junkyard over there with broken down cars, and they're half on the road and half on the sidewalk, and it's like I don't know why bylaw isn't doing something about these people. But ever since they moved in, it's been nothing but problems. So we're gonna keep on it. Thank you, thank you, thank you. Thank you, everybody, for smashing that like button. Lori, no update yet. Anything that comes in, I will be bringing it to you. Right now, I am keeping an eye on the live feed for the court. As soon as it starts, I will be bringing it to you. It will be starting momentarily. Yeah, it is very sad that people treat animals like that. Like, the animals depend on you, right? Thank you, Sonia. Yeah, it's sad. It's sad. And it's like it went from barking to crying when it was like minus 35 out, and we called police and everything, and nothing was done. Yeah, and this is not a dog that can handle it's not like a husky or something like that that's used to the cold. And even in minus 35 degrees Celsius, it's like, no, forget it. They're not made for that. So we all know that this always runs a couple minutes late, but we are able to stream it today, so Grandma 3G. Keep retracting messages. Why? It's getting to the point where I don't care. What are they going to do? Lock up a almost 60-year-old woman for saving a dog? It's like, I've told them I'm getting ready to just have somebody take it because this is ridiculous. Yeah, right? And it is a very friendly dog. Very friendly dog. Okay, Grammy. But yeah, I'm getting ready to have that dog napped and bring it to a home where it would be, if I was younger and had more strength for a dog that size, because it's a pretty big dog, I would take that dog myself. Janika, I have not seen her autopsy report yet. I will go and look for that. No, they don't have security cam. I have security cameras all around my house. But I don't care if security cameras or not. Absolutely. Okay, I keep refreshing you guys, so as soon as it starts, I will jump over and bring it to you. Well, something is going to be done, or I'm just going to go higher up in the chain. Or go to the newspaper, one of the two. It's a neighbor's dog. Oh, hello, Shelly, and welcome. Glad you could make it. We will be starting anytime. We know that they always run a little bit late. But it does say that I can stream it, so. Yeah, Dawn, I have a broken back, so I can't take the chance of it maybe running after another animal or a cat and just pulling my back out. Yeah, they got it tied to a fence in the backyard, to a chain link fence. It's cruel. Yeah, they are always late. Okay, they're live.
We would just set the state's motions to continue for Friday morning. And we had asked for either a status conference.
Whoops, sorry,
We got
guys.
an email from the court saying we could have the status conference. The state's purpose for asking for a status conference was just for scheduling. And if we still need to have our hearings on our motions to continue, that's fine. But we did have some concerns, and I'll let Ms. Smith address our concerns for the hearing tomorrow on the state's motion to reconsider in terms of new evidence or possible new evidence. We want to make sure we're giving the court accurate information and Mr. Pryor accurate information. And then we also had, we filed a motion to continue on Mr. Pryor's motion to dismiss. I would note we were initially informed that all 5 of Mr. Pryor's motions were set for next week. But I believe, and again, if I'm wrong, someone feel free to correct me, that it is only the motion to dismiss. However, 2 of his other motions also include a request for dismissal. So we need one clarification, and we would still be wanting to have a motion to continue that for the state to have adequate time to prepare.
Okay, so to clarify what's currently on the calendar, tomorrow morning scheduled is the defendant's motion to sever and the state's motion for reconsideration. Next week on the 23rd is the hearing on the motion to dismiss filed by the defendant. But I understood with the other motions Mr. Pryor filed, and those were filed under seal, that those were not yet scheduled for hearing. So in the court's mind, we've got the 3 pending hearings, 2 for tomorrow, and the hearing next week on the defense motion to dismiss. In terms of this morning, then, we did indicate this was a status conference. Is it then the state's intention you want to argue the merits of the motion to continue your motion to reconsider? And I'll note the court already issued an order on the motion to sever, denying the motion to continue that. So we will go forward on the motion to sever, but on the state's own motion to reconsider tomorrow, that has not yet been determined. And on the short time frame here, I'm just curious as to whether you are indicating you want to hear the motion to continue at this time. And if so, I'll need to inquire as to Mr. Pryor as to whether he's prepared to do that. So Mr. Wood or Ms. Smith, do you want to clarify that issue?
Yes, Judge, I think it would be the state's request that we be allowed to argue that this morning, or at least provide the rationale to both Mr. Pryor and the court. We filed that motion, I believe, late last Friday. I'm not sure where it sort of went through in technology, but so yes, that would be our request this morning.
All right, Mr. Pryor, so on that limited issue of whether or not we should continue the state's motion to reconsider, do you want to, and are you prepared to hear argument on that this morning and respond to that? Or would you request that we take that up at a later time, knowing that we don't have much time between now and when that's set?
Judge, I did receive the notification. It was close to 5 o'clock on Friday. However, I think I'm prepared to argue the motion to continue the motion to reconsider. I think that's appropriate to argue that today.
Okay.
I'm fine with that, Your Honor. Thank you.
All right, Ms. Smith, then, if you'd like to make argument as it relates to the state's motion to continue your motion to reconsider, you can do so at this time.
Wonderful. Thank you, Judge. The state is requesting that there be a short postponement of the hearing on our motion to reconsider, essentially for 2 reasons. 1, the state wants to supply the court the most accurate information it can. And 2, we want to be able to get the information to Mr. Pryor in time for him to evaluate and address it as part of sort of our due diligence in sort of a discovery process. Last week, in anticipation of our hearing, we sat down to meet with our witnesses and doing our due diligence, double checking things, we learned that a couple of the people we had anticipated calling or relying on their testimony had a meeting with personnel on March 1st with the court, and that some of their information upon that meeting in Ada County on March 1st, it was different than the state had been originally given. It's a situation that evolves. Dealing with budget projections is sometimes reading like a crystal ball. And so that staff had originally given information to our witnesses, and they relied on it, and that resulted in our exhibits. And so in talking to those people and getting our witnesses ready, we learned that some of the information that we had originally relied on may now be different post the March 1st meeting. We asked the representatives to get us updated information or to talk to us about it, and they indicated that they were reluctant to do that without permission from the trial court administrator, for Your Honor. And so we called her, and she indicated that she was reluctant to give us the additional information without permission from you. I recognize, we all recognize that everyone is working really hard to do things by the book and to do things very fairly. And so the state is in a position where the information that we provided Mr. Pryor in anticipation of this hearing may be different. Maybe to the benefit of Fremont County, maybe not, we don't know, but the people we were relying on are reluctant to give us some of that information without permission from the court. And so we would be in this position if they change their mind or they give us updated information this afternoon, then we're turning things over late to Mr. Pryor, which is not fair, and we know that, which is why we filed for the continuance. We are simply working with our witnesses to get you as accurate an estimate as we can. We recognize the court and the trial administrator were doing their own due diligence and evaluating the situation. It's just our witnesses were unaware of that meeting, and they were unaware of how things had changed. And so we're in a difficult spot. I don't want our witnesses to get up there and say something that's inaccurate to the court, but we do not have the ability to get them accurate information because people feel they can't speak without permission from the trial court administrator, who indicated Mr. Wood that she wants permission from you to talk to us.
All right, Mr. Pryor, what's your response to the state's request to continue their hearing on their motion to reconsider set for tomorrow?
Judge, and I don't want to belabor the point. We had a motion to change venue, and that was back last year, in the late fall of last year. Prior to that hearing, the state intended to argue and wanted to argue that they wanted to provide additional evidence and sought permission of the court to provide that additional evidence. I filed a motion to continue that because I did not want to get information dropped upon me at the last minute. However, the court, in its discretion, denied my motion to continue and said, listen, the two of those hearings are linked together so extrinsically that we need to address this all at one time. Subsequent to that, the court issued an order, changed the venue to Ada County, and denied the state's motion to allow the jury to be brought to Fremont County. The state then filed a motion to reconsider. But before the state filed the motion to reconsider, at that venue hearing, the status before the judge specifically said, Mr. Pryor, I'm not going to allow them to just dump information on you and not provide you an opportunity to respond. And I appreciated the court doing that. But what the court did not do is give Ms. Smith and Ms. Wood and Ms. Blake an opportunity to take a second crack at the apple. And now what we're dealing with is this, Judge, 3 or 4 months later, in excess of 4 months. We are now dealing with an opportunity where now they're calling more witnesses. But they had their opportunity to present the evidence, and they insisted on going forward on the day of the venue. They insisted, even though I said I don't want to go forward, they insisted on going forward. And now what they do is they drop this information on me, saying, here's our additional evidence. And they provided facts, they provided costs, they provided details, they provided information that they think supports their position for the court to reconsider its prior ruling. And the words reconsider, Judge, are very important because we've been down this road before. When Mr. Means was on the case with Ms. Vallow, Mr. Means filed a motion to reconsider, and this court ruled that there is no legal authority for the court to entertain a motion to reconsider. And if that was the court's position then, I would like it to be the court's position now and be consistent, that they don't get to go forward on a motion to reconsider. Not only that,
Mr. Pryor, I'll say there's a little difference here because in my ruling, I certainly left the door open. Part of the ruling was we were so far before trial because trial was scheduled so far out that even some of the information would maybe not be relevant or would be stale by the time we were actually getting to trial. And so unlike in that prior situation that you've mentioned with the other case, I think I did leave the door open here for the state to take a second opportunity for me to consider that. So I'd like to make that distinguishment.
okay. But Judge, that additional opportunity, and I would ask the court to go back and review what you said. My impression, and I may be wrong, is that the court said, you know, I'll allow Mr. Pryor for you to provide information, allow the state to provide some additional information. Well, what is happening is the state has now disclosed 4 or 5 additional witnesses. They provided additional information. And if we rely on what Ms. Smith says, it's saying, Judge, you know, when we first provided you the information several months ago, I don't know where the source of that came from, but they're now saying, Judge, you know, we gave you some inaccurate information. And when we were providing our response and or providing our authority to supplement the record from the previous hearing, we're now saying our information is not accurate and it's not correct. So Judge, you know, after Mr. Pryor has filed his response and addressed all of their concerns and addressed why I think it should stay in Ada County, the prosecutor is saying now, after I have filed a response, Judge, a week later, well, maybe our information isn't quite as accurate because now that we look at this thing, we're getting some different information. Well, you know, Judge, please forgive me if I'm a little skeptical about what this new information is going to be. And frankly, Judge, when they provide that new information, then what's going to happen is I'm going to look at it and change my tact potentially. And I'm going to need to get an expert witness. And I'm going to need to subpoena people. And this motion to decide what we do in terms of venue, where the jury is going to be sequestered, is going to drag on. Because if they provide me that additional information and it changes dramatically their numbers and to their benefit, they're going to cause me to have to do a full-blown analysis of what they're suggesting. Because I didn't trust their information the first time, and I surely don't trust their information the second time. And I think this is just another mechanism for these folks to try to continue this matter so that it puts a very difficult place for us to have a trial in January. And Judge, I would ask the court to deny their motion. And I would ask the court to not even allow them to present evidence because I view this as a motion to reconsider. And whether the court opened the door or not, I don't think they should get a second crack at the apple.
May I be heard, Judge?
Go ahead.
Briefly in response, we are not saying that the original information we gave was inaccurate. We are saying that given the way budgeting evolves, given now that the parties know it's going to be in Ada County for jury selection at least, and potentially for the whole trial, that the information our witnesses relied on may have changed. In an abundance of caution, we are attempting to make sure that the information that we present at a hearing is given to Mr. Pryor ahead of time so he has a chance to look at it. We cannot do that because the witnesses feel they cannot discuss the changes or discuss the situation without permission from the court. Nobody's at fault. Everybody's just working really hard to follow the rules. And so we need permission from the court to let these people talk to us to see if the original estimates remain accurate or if things have changed, potentially to the benefit of Fremont County. And that is part of our due diligence in providing as close to an accurate estimate of academic impact as we can to the court. The second piece, and just so the state's position is clear, the court, and I've reviewed the entire YouTube proceeding on the change of venue, the court repeatedly actually granted Mr. Pryor's motion to continue matters. There's multiple sections where that's brought up. And the court, when respecting his need for notice, when the state asked a question that could verge on opening that door, the court limited those questions, but did tell the state that they would give us an opportunity to present academic evidence in the future should we feel the need to do so. So I just wanted to make sure the state's position is clear that the court was correct. And I agree with you, Judge, that you did not preclude us from bringing it up in the future.
All right. Well, this is a motion to continue, and I've considered the arguments and concerns raised by both the state and Mr. Pryor. I'll note the court has broad discretion in granting a motion to continue. I have to look at the overall administration of this case. As everyone knows, we're set for trial in January. Things are going to march along quickly between now and then. This is an important issue for the court to consider. As I have learned, it's going to take a lot of planning and effort and coordination amongst the counties in order to conduct the trial, where it's currently scheduled to take place in Ada County, which is what's been ordered at this point and has been approved by the Idaho Supreme Court. In terms of this motion, I'll note, first of all, this is the state's motion, and the state is now requesting the continuance and has raised a valid and legitimate reason in that they indicate that information that has been submitted in support of the motion may need to be corrected or updated. And so I do find there's a rational basis for bringing the motion, that it's not done simply for an unnecessary reason to delay. I understand the concerns raised by Mr. Pryor in terms of how that may require him to make additional preparation. And then in a moment, I'll get to the point of this argument that some permission from the court is needed in support of this motion. So given that the state raised this issue prior to the hearing, and in the interest of having true and accurate and correct information for me to make a determination, I am going to grant the state's motion to continue, their motion to reconsider. However, I want this continuance to be brief because I don't want this to impact any other aspect of the case in terms of it moving forward towards our trial date. So I'm going to have a few questions then for the state in terms of when you are going to have your additional information, when you can get that to Mr. Pryor, and then I don't want this to go out more than another 30 days, quite frankly, because the motion's been pending for a long time. We need to keep it on track. And then in terms of this permission from the court, I'll get back to that in a moment. But either Ms. Smith or Mr. Wood, what are your thoughts on when you will have your information so that it can be supplied in a timely manner to Mr. Pryor?
Your Honor, it's sort of intertwined with my next question, because I agree with you. I'm not sure that the court has to grant people permission to speak to us, but I recognize what they're saying. So if people will speak to us, we don't need more than 30 days. In fact, I suspect we need less.
Let me approach that point, because I don't go around and just give people permission to do something or not. In the case, I either order something or I don't. And so if you think somebody needs to be ordered, you need to submit a request for an order, and then an order would be issued if I find it appropriate. If not, permission's not something I grant or deny for people to speak about the case. That's governed by the rules. And I have not had any request, or no one's asked me to order anyone to talk about this issue. So I just want to be clear on that. Are you saying you're going to seek an order from me to compel someone to speak?
If their position remains that way, yes. And that's, I will be candid, I was surprised by that as well, Your Honor. So forgive me, we're a little, and so we will clarify with the individual, and it's the trial court administrator who works for your circuit. I think she wanted to make sure that she wasn't violating any rules. She's had a few days to think about it. So we will circle back with her to see if her position has changed. And if she feels that a court order is necessary, we will file that. We can know that certainly by Monday morning. I want to respect people's efforts to do everything by the book. I want to give them the opportunity to proceed. And if we need a court order, we'll do it by Monday.
All right, so when will you have your updated information available to provide to Mr. Pryor, if that's your thought on when you'll get that?
I certainly think could provide it within the next 2 weeks. And I think I'm overstating that amount of time, but I don't want to get into a position where it's taking a while.
Okay. Well, and then that would give an additional 2 weeks. The issues out there, Mr. Pryor, the numbers are numbers. If you need to further review those, I think 2 weeks would be adequate time, knowing that the issue's been pending for a long time. So I'd like to look at setting a hearing then about 30 days out on the state's motion to reconsider. We'll vacate the hearing scheduled tomorrow morning. And let me look at my calendar for a moment.
Judge, before we do that, could I make a comment?
Go ahead, Mr. Pryor.
If they're intending to seek information and allow the trial court administrator to speak, I would like that order to include my ability to discuss it with the trial court administrator and have the opportunity. It seems that having it one-sided would be of a concern to me. So if they're going to ask this trial court administrator and submit an order, I'd like that order to include that I am permitted to contact the trial court administrator and discuss the same issues with her. Because quite frankly, Judge, if they give me information exactly 2 weeks from today, that gives me 2 weeks to find an expert, to find another trial court administrator or another person who can address those things. And then I'm in a position where I have to find an expert. I have to discuss it with an expert. And my whole concern about this thing goes back to this, Judge, is if the information has changed or hasn't changed, if nobody's talking, how do they know that? And this just seems like a delay to me. But I will obviously do what the court directs, but with the understanding that if you give me 2 weeks and I get the information in 2 weeks, Judge, I'm going to be in a very difficult position to provide a response. And I've already provided a lengthy response, and I'm going to have to go over it and do it again. And that seems to prejudice me a little bit, at least from my perspective, Your Honor. But I don't want to delay this either, Judge. I'd like them to have it to me within a week. And I don't see that there's any difficulty that they could not get this information to me within 7 days. It can't be that complicated.
All right, I'm considering that, Mr. Pryor, but I'm not giving any advisory opinion on any order that I haven't issued yet. So if an order is proposed, I'll consider that to see if it's an appropriate order given the circumstances.
Your Honor, just so the court's clear, the state wouldn't object to Mr. Pryor having access to that to anyone we would talk to.
Very
I mean,
well.
they're public officials.
Okay, I'm looking over my calendar, which is not got a whole lot of availability because trials have started again. Let me confirm this. I think I've got Wednesday, April 20th.
That works for me, Judge. Thank you.
The state, I can make that work, Your Honor. Let me check. I believe my colleagues can. Yes, that works for the state, Your Honor.
Okay, let's schedule that for 9:30 a.m. on Wednesday, April 20th. All right, that concludes then on the state's motion to continue their motion to reconsider. Is there anything else we need to bring up this morning at this hearing?
Judge, in regards to their motion to continue the motion to dismiss, I would like to clarify that it is one motion. Now, attached to part of that were two other motions that address some other issues as they relate to Ms. Smith and Mr. Wood. I'm not anticipating arguing those. I'm going to argue the motion to dismiss that was addressed in my brief and partially addressed in the other two briefs. And that's all I'm intending to discuss. Now, if the state needs more time on the 23rd, Judge, I will stipulate to giving them additional time. I did provide them 3 lengthy briefs, and if they need some additional time, I'm not opposed to them having that additional time. And we can vacate the 23rd if they would like a brief delay in hearing that one.
Your Honor, that if I can, we appreciate that. The motion to dismiss the primary motion, it is a lengthy motion. We would appreciate more time to respond to it. I'd note that in the when we had the scheduling conference on that, there was no time limit given on the state to respond, but we would like to provide that to Mr. Pryor in an adequate time as well. So we would like to continue that. We would like to get some type of scheduling in place for the other motions as well, Your Honor. As Mr. Pryor just said, they are interrelated, or that he would be arguing portions of them. And so we would like to get those on the calendar as well, so we can respond and get those taken care of.
Judge,
Hold on, Mr. Pryor. I'd like an opportunity to respond. In this case, then, we do have set a motion to dismiss on March 23rd at 9:30. The state's requested a continuance of that. And are you indicating, Mr. Pryor, that you don't object to continuing your motion to dismiss?
I don't object, Judge. I understand that the primary motion to dismiss was, my recollection was in excess of 50 pages long, and the 2 accompanying, although I'm not going to be arguing the accompanying motions that are different, 2 of the other briefs included facts that addressed the motion to dismiss as well. So given that, there's basically 3 briefs that address the motion to dismiss, and I did it in that way so that there was no confusion. As far as the other motions, the 3 other motions that I see, I would prefer that we allow the court to address the motion to dismiss. And at that point, once the court addresses that, if the court grants the motion, the other motions become moot. If the court denies the motion, then I can set a time to notice the other ones up. That would be my preference, Your Honor.
Well, with these lengthy motions, and again, going through my calendar, I do have that April 20th date open and could use that time. I do have this concern, though, that if there's a ruling or I need to take a matter under advisement on the motion to dismiss, I would prefer to have that argued and heard on the 23rd, so that then there's time for the court to get a decision and possibly not have to go forward on the other pending motions. I guess I'd like to know why, again, on this motion to dismiss, that was actually, the motion was filed back in June of 2021. I mean, it was filed forever ago, and I understand that it took quite a time and an effort to compile all of the record that is necessary for review from the grand jury, transcripts. And so I don't blame necessarily that delay on getting the hearing set, but now, again, continuing that out, where I don't really see time in my calendar. I could probably get something before the 20th if I looked, but we're either setting everything together on the 20th, or else we could still go forward on the motion to dismiss as scheduled on the 23rd. And I'd just like to know why parties couldn't be prepared to hear just the motion to dismiss on the 23rd, even if I were to allow for any additional follow-up briefing if required on the 23rd.
Judge,
Go ahead, Mr. Pryor. Why can't we do this on the 23rd?
Judge, and I will let Mr. Wood know, and Ms. Smith and Ms. Blake. I hope I'm not missing anybody. I don't intend lengthy argument on the 23rd. My concern is that some of the facts that I addressed in my memorandum are things that I'm not going to state in public. I'm going to probably submit on my brief and with very little argument, because I'm concerned about the privacy concerns of some of the citizens and some of the other issues. So at this point, I'm probably going to just submit on it or offer very brief argument. And I would be receptive to the state arguing and then supplementing my brief with a response within a period of time and allowing me a supplemental response and then allow the court to make its ruling. If that's the way the court wants to go, I don't think that would prejudice the state. They would still have the opportunity to submit a brief and get that to me within a time after the hearing on the 23rd, and I would be okay with that, Judge. And that way we keep this thing on track. If that's where the court envisions going, I fully accept that opportunity, Judge.
All right, Mr. Wood or Ms. Smith, I'd like a response to that in terms of holding the hearing on the 23rd, knowing that really on a motion like that, it's likely that it will require further review, and it's not a motion that court is likely to make a ruling on from the bench. Is there a reason why the state is not going to be or couldn't be prepared for argument on the 23rd with an opportunity to submit potentially a written responsive brief after argument?
Your Honor, if that's the method the court chooses, we'll certainly abide by that. We would like a little more time to adequately respond to the brief. I believe it's 55 pages long. There's a lot of points raised. There's a lot of case law to go through with it. And we obviously have already started on that, but we think the most effective method would be to have a little more time to prepare that brief. If the court does decide it wants to hear it on the 23rd, we will argue, but we would certainly want additional time to brief it after.
Okay, fair enough. Given the constraints we have at this point, I'm going to deny the motion to continue the hearing that was scheduled by the defense on their motion to dismiss for the 23rd, keeping in mind that there's likely to be a request for the parties to submit additional written argument or briefing post-argument at the hearing. But so we'll keep that on the court's calendar, and that's scheduled for 9:30 a.m. on the 23rd, and we'll hear argument at that time then. All right. Mr. Wood, is there anything else then on the case we need to bring up this morning?
Not from the state, Your Honor.
All right, thank you, Mr. Wood. Mr. Pryor, anything further for the defense?
Your Honor, I would just like the day as to when the state's to provide me the additional information. If I could have a specific day, I would appreciate it.
All right, I appreciate that. I neglected to mention that. So with the hearing we scheduled on the 20th for the state's motion to reconsider, let's schedule a time for disclosure of any additional information in support of that motion. We've got 4.5 weeks until that hearing. So would the state be able to have that to Mr. Pryor by the 1st, April 1st?
Yes, Your Honor.
All right, that'll give you about 19 days then, Mr. Pryor, to review that information for that motion. So the state will be required to file any supplemental information and provide any further information in support of their motion no later than 5:00 p.m. on Friday, April 1st. All right, counsel, thanks for your appearances this morning. Then that will conclude the hearing, and we will see you back on the record tomorrow morning.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Okay, so there we have it. Now, I know a lot of yous were asking some questions throughout. I just wanted to keep my focus on hearing what was being said so I could answer those questions at the end. So what we have here is we have several different motions to dismiss. We have, yes, this is all routine. I know a lot of you are getting flustered. I am too, but these are things that need to be done. This necessarily is not Wood delaying things. This is the prosecution this time. So the hearing that is set now for April 20th, we'll address that one first. The prosecution's been given till April 1st to give all their new information or new witnesses that they are going to bring forth regarding this change of venue. They have said that you got to kind of read between the lines when they're saying things, because this is all sealed. So they got to be very careful about what they're saying. So the change of venue, the state's motion to reconsider, they're going to bring forth some more information. Now, they have made it clear that they don't know this information, if it's going to be good or bad for the prosecution or good or bad for the defense. They really don't know, because whoever is holding that information refuses to give that information to the prosecution until the judge says that it's okay to do so, because it's from sealed documents. So that's the issue that they're having now. So what the prosecution has to do now is they have to go and speak to the administrator. They have to try and get the information. If they still refuse to give the prosecution the information, this new information, then they have to come back to court and get the judge to order it. I don't know why he just didn't order it this morning, but he didn't. He said that he's going to make a written somewhat of an order that information can be released, and then that the prosecution can then release it to the defense, and then they will have a hearing on that motion to reconsider on April 20th. Okay, so we have another hearing still tomorrow. Now, I'm not sure, because at one point he said he was going to vacate tomorrow's morning hearing, because there's one set for 9:30 a.m. and there's another one set for 11 a.m. So I will be on here. Will be 11:30 a.m. my time, and we will be waiting for that to start. There was another one scheduled for 11 a.m., which would be 1 p.m. Eastern. So I don't know which one. I'm going to see if they get that onto the record, to see if it's the 9:30 a.m. one that they've canceled, or if it's the 11 a.m. one. I'm not sure. I didn't hear him say what time he would see them tomorrow morning, so I'll have to check that out. But those motions, they've got, I think they're going to start on the motions to dismiss. Now, there's 3 different motions to dismiss. There's a motion to dismiss all charges. They want all the charges against Chad Daybell dismissed. That is the one I believe that they are going to be doing tomorrow. So you'd want to be there tomorrow to hear this one. Now, and what I could get from what John Pryor was saying is, if we get a motion to dismiss and it's allowed that all his charges are dismissed, then they're not going to need the other 2 motions to dismiss, which they are going after the prosecution. They want Rob Wood and Rachel Smith dismissed from the case. So there's one primary, which are the dismissal of all charges. And then the secondary is the motion to dismiss prosecutors Wood and Smith. So hopefully that makes sense to you. We don't know yet, Betty. I don't want to put stuff out there that isn't fact yet. We don't know what it is about, because what they're discussing has been sealed. So if it's been sealed, then we can't possibly know what it's about. Yeah, but I mean, I don't like John Pryor either, but what he is doing is in line with what a defense attorney should be doing. I mean, I don't know if I would go for a motion to dismiss Wood and Smith, but he must have reasons for doing that. We will find out that either tomorrow or on April 20th. Okay, I hope that explains it. We don't know. We don't know, Pepsi Girl, because all that paperwork has been sealed. Yeah, he knows what he's doing. Like, as much as we don't like him because he's representing Chad Daybell, he is a top-notch attorney. So I have to give him that. I don't think he's like Mark Means at all. We've seen very little actually coming from him, and the things that he is arguing is what any other attorney would argue. From my dealings in criminal law, I see this often, and he is following the route that's usually taken there, except for the motion to dismiss Wood and Smith. As we know, Mark Means had already tried to get Rob Wood off this case, and it was not successful. So whatever this new evidence he has that's come out, I don't know. We won't find that out until tomorrow. He does want, Betty, he is going for a dismissal of all the charges. And that is not out of the ordinary. Okay, this is probably going to be happening, and he's going to be asking for this quite often until there's a decision made on it. And that is normal throughout a criminal case, especially with the death penalty case. Yeah, he is, as much as we don't like him, he is just doing his job. He is nothing like Mark Means, that's for sure. I don't think he's going to win on a lot of this either. I do not believe that Rachel Smith or Rob Wood will be removed. I don't think that will be happening at all. I also think that he is going to win with this motion that the prosecution has brought forward to reconsider the change of venue. I think that is going to be denied to the prosecution. I think it's going to stay exactly where it is, no matter what they come up with. I think Pryor is going to win that battle. But what I don't think Pryor is going to win, don't forget, there's different motions here that are being brought up. Some are from the prosecution, some are from John Pryor. Now, the ones that the prosecution have brought up, I think they're going to lose it. I do not think that anything is going to change there. I don't know what the new information is regarding the change of venue, but they have filed the motion to reconsider. I don't think they're going to win that one. I don't think the prosecution is going to win that. So that'll be a win for John Pryor, because that's what they want anyway. Now, as far as the motions that the defense has filed, I think that he's going to lose both. I don't think Rob Wood and Rachel Smith are going to be removed from the case. And I do not think that the charges are all just going to go away. So I think those ones he's going to lose. But I mean, he could be cited for not doing his due diligence if he didn't do that for his client. Well, I mean, Nancy, there's a lot of things that still need to be done before it even gets to the trial date. It's not just normal housekeeping. This is in depth. Yes, and we all want him. That is the bottom line. Thank you so much for that, sarcastic. The bottom line is we need to hear all this stuff and have the judge rule on it. The judge has to give him his right to his motions, because if not, then this could be a mistrial, or this could be thrown out. This is their one and only shot. So as much as we are getting, flustered and everything, this has to happen so he can't come back and appeal anything. This is taking away reasons for appeal. Yeah, it doesn't matter where he goes. I'm in Canada, and I talk a lot from people from different parts of even Canada about this. So yeah, we don't want it thrown out on a technicality. So that's where things stand. We will be back again tomorrow morning. I'm going to have to keep checking that record because I don't know what time. I believe it is the 9:30 that has been vacated. He didn't give us a time to when tomorrow's hearing is going to start. So I'm going to have to keep checking the docket. It's hard for me to do from here. I got to search for other information because I can't get the docket. I can get the filings, but I can't get the docket. Muffin Top says, what are my thoughts on the witness statements? I don't know. There's thousands of witness statements, so you're going to have to be a little bit more precise with the question for me to be able to answer that. Okay, Teresa, you take care. Yeah, that's all in the evidence. I mean, that's why I said I don't think there's no way that the charges will be dismissed, but this is one of the things that John Pryor has to do as a defense attorney. He has to file a motion for that. The witnesses, I believe those are, let me just see. I was taking notes as we were going here. Okay, the witnesses, that has to do with the prosecution's motion to reconsider the change of venue. So I do believe that witnesses that are going to be called in that are people, expert witnesses who have done polls and came up with the cost of things and stuff like that. It's going to be expert witnesses, not just like normal witnesses like any John Doe. You know what I mean? This is going to be the expert witnesses, I believe, have come forth with some new information that may benefit one side or the other. I think it's a little bit more than the details. I think it's going to have to do with either something that could maybe perjure somebody or something that somebody said and testified as an expert witness to that being true, that they've come to find out it's not true. That's what I think it's about. Because they don't want to give up the information freely. So I feel like it's something that could go against them, which would be something like a perjury or something. So they want to get the corrected information into the record, so they can't be later charged with perjury. Yeah, if you go back, you guys, to what some of my very first readings, I think in my community tab, I posted that read that I did. Let me just see if I can find it. Let me just go here. Hang on a sec. I'll find you the link to the read and I'll put it here. I think it's Who's Fooling Who or something along them lines. Hang on a sec, you guys. It was just recently, too. Hang on, you guys. Okay, I can't find it there. Hang on a second. I can't see chat right now, so. No, Lori, I just popped back over here to see if you guys had anything saying here. No, Lori is not competent yet. Let me just find, give me a second, you guys. Ugh, crap. Okay. I've got a lot to go through. Hang on a sec, you guys. I'm going to find it for you and give you the link. Hang on, I'm almost there, you guys. Just give me a second, patience. Okay. Okay, here it is, right here. I'll give you it right now. Okay, so here is the link to that read. And that read was back in June of 2020. And if you haven't seen it, you need to go back and watch that right here. I don't think the trial is going to be severed yet. They can't be forced to, but if they want to, they can. So Chad, I think they're both going to testify against each other and point the fingers at each other and at her brother, Alex. Like I said, you guys, I also got the Barry Morphew stuff up. The new orders from the judge are up. I did that live this morning. So if you want to check that out after here. Oh, thank you, sweet Sherry. I appreciate that. I really do. Motivation to keep bringing you guys this stuff. Thank you so much. Let me see if there's any other questions here. Grammy 3G, you're very welcome for the clarification. You don't have to testify, Betty, but if they choose to, they can. No matter what it's about. And I don't know. He's not going to get the severance. Not yet, anyway. I think there's still a little bit of time to sever them. I think, if anything, I don't think that decision is going to come much before April or May. I don't think they will give that decision, because if she is found competent in the next couple of months, then they will still be tried together. Janika, I'm going to remove that because they've had the autopsy report from Tammy for a long time now, and it's not going to be we're not going to be able to see that or hear about that until trial. So she won't. She won't. That's why John Pryor is trying to get this to go ahead, because he would rather have a trial while she's still being held as incompetent. And we don't mention other sources here, Janika. Please don't do that. We don't mention other news sources or where you get information anywhere else. That's how I keep everything in here fact driven. So please do not mention other creators, other news sources, anything in here, or any information you've heard from that. I keep things verified here. So until I have it verified, I will not speak on it or allow it to be spoken on, just to keep everybody not questioning things. Hello, Sammy Smith. No problem, Des. Pepsi, he can blame Lori, he can blame Alex. If he chooses to testify against his wife, that's his choice. It's just they can't force him to testify against his wife, against his choice. But if he chooses to, there's nothing they can do about it. No, what's going to happen is at some point, because the trial is going to start in January of 2023, I believe that decision is going to have to be made within 6 months of the trial starting. So if she's not competent, I'm going to say by May, June, if she hasn't been brought back to competency, then I could see them getting their sever. Exactly. Yeah, blame the dead man. He's dead, but there's too much evidence to prove that Chad was there. Yeah, I think they're both going to point the finger at each other and Alex. But, I mean, Chad puts himself there. So, puts himself where the children were buried. And his message to Tammy saying that he shot a raccoon, it's now buried in their pet cemetery. And that's where they found Ty Lee buried. No, it's not going to be up to a jury. If she is not found competent, then she will not even go to trial. She hasn't even been arraigned yet. So if she's found incompetent, she will not go to trial until she's brought back to competency, what could be mega years. So she'll be just locked up away forever. So with that, you guys, I'm going to let you go. If you have not subscribed, I suggest you subscribe. I will be going live again tomorrow with the rest of this to see what is going to happen with the motions to dismiss. And we will see what happens tomorrow. Okay, so until the next time, you guys, please take care of yourself. Please stay safe. Thank you to my mods for being here. Thank you to all of you for being here. And we will learn more tomorrow. If you haven't seen the orders that the judge made regarding Barry Morphew, go check that out. That was uploaded this morning. Okay, so take care, everybody. See you tomorrow. Bye-bye.